ego. You'll get sharp opinions on court rulings, law, enforcement overreach, and how to protect your rights. He teaches you how to control your body, your mind, and your future. Discipline equals freedom. Follow Michael Ehline before he hits 10K. Real content, no filters. Marine, fighter, attorney. Follow now.
Well.
If you're not
What's going
working
on,
out,
guys?
drop and give me 20 right freaking now.
Sorry about that. I'm still having a hard time trying to figure out how to use all this stuff, but hopefully you get the idea. So what's going on, everybody? I am attorney Michael Ehline. I am an attorney licensed in California and Texas, and I am going to bring a show to you today. Hopefully Alan will be able to show up. I have him scheduled as a guest today at noon. And Alan Beck is one of the preeminent Second Amendment rights lawyers in the country. And I discussed this a little bit earlier with you today that I would have him on today. So, hey, what's going on, Rami? So, Rami, I don't know if you noticed, but I sort of fixed the camera, but now it's showing my computer monitor. Let me see if I can get it out of the way a little bit. All right. That's a little better. I don't know. What do you think, man? Like I've got it in vertical, but you can, hey, Gloria, but it shows more of what's going on the screen. So I've been buried, man. So I haven't had a lot of time to prepare for this one. I'm just trying to, let me just see here. Let me see if I can blow this up for you guys a little bit. I think most of you can tell I'm not the most tech savvy guy on the planet. Let me see if this works better if I do it like this. That's kind of cool. Hey, what's up, Josephine? Yeah, I'm just kind of waiting for people to come into the stream. And I'm trying to get the image just right so I can kind of go over this case with you. But we're going to talk today a little bit about the Second Amendment. And I have Alan Beck, who's involved in one of the biggest cases in our time, for sure, who works with my firm. And hopefully he'll make it here to talk to us. But this is the case of Wolford versus Lopez. So we'll start out with Wolford versus Lopez. Actually, you know what we'll do? Before we get too far into this, but let me go ahead and get the screen squared away so everything fits. Oops. Hold on. Oopsie daisies. Just bear with me, guys. I'm trying to get the screen just right. And thanks for joining me. I hope you guys had a good 4th of July. This should be a good one. Thanks, Gloria. Right on. Member for 8 months. Right on, Gloria Ad. Joseph Doe, thanks for coming in today. Let's OTVO, as always, man. I love it that you've stayed a member of Team MPE. Say hi to Brick Jonesy for me. Miss having him on the show. It's always nice to get a different point of view. Let me see if I can get this any smaller for you guys so it can fit in the screen. Now it looks like that's about as good as I'm going to get. I'm going to get it for you, but it doesn't look like I can really move it around too much. Let's see. Let's just look at so I changed the camera angle, guys. So bear with me. I'm trying to make everything look really nice and tidy for you. So that's how it would look. That's how it looks with me that way. That's how it looks with me that way. Okay, so maybe we do it that way. What do you guys think? Let's blow this up a little bit. Let's see how it looks now. There we go. Okay, I think that's how we're going to do it. Let's get it a little bit bigger so you can see what I see. Hopefully you guys can see what I see. So I went in vertical today because Alan is supposed to join me on his cell phone. So let me really quickly, what I'm going to do is I'm going to sort of share with you the state of Hawaii's arguments based on an old video that I did. And now this is the Hawaii versus Wilson case. Some of the facts I got a little off, but the history is what I want you to learn. And as I'm doing that, I'm going to put my mic on mute. And I'm going to give Alan a call while you guys watch this video. It's like a primer. so you can learn a little bit about what Hawaii is trying to argue and how it conflicts with the Bruen case. Okay, so let's get into that first, and then we'll go from where I'm coming from. So what I want to teach you about today is a classic Leviathan versus Locke type of an argument where natural law and the monarchy comes in. Scotland was always at war with the English. They wanted their own Scottish king. The English wanted their own English king. The Scots wanted a Catholic. The Scots became oppressed because the king had superior technology. Ultimately, the king was able to conquer Scotland, and a lot of the Scots weren't happy about it. Hawaii, similar situation. So I want to get through the history really quick so you can understand what happened. This is State versus Wilson. This is a Supreme Court of Hawaii case. So what this means is that rather than go to the U.S. Supreme Court or the federal courts, Wilson handled this through the state of Hawaii, through the state courts. But it is a Second Amendment issue. Wilson was basically arrested for trespass. He had I believe it was a 45, a 1911 model pistol in his waistband, I believe. And he was out with his friends, and he was arrested for trespassing and basically argued that it was a violation of his Second Amendment rights because basically, Hawaii has no way to get a firearm. It's virtually impossible to get a concealed carry firearm, and they've basically tried to relegate it to being something like where you can only use it for your home defense. So there really is no way to use a firearm without getting in trouble like Wilson. So Wilson went ahead and fought it. And now what I want to do is get into you what the Hawaii Supreme Court did. The Hawaii Supreme Court basically ruled that ancient Hawaiian principles from the king, where the king passed a law that you couldn't have any weapons. So since the king passed this law, ancient Hawaiian aloha spirit is what really matters. And because Bruen talks about the history of a particular state and its firearms laws, that means that under ancient Hawaiian law, which has nothing to do with the U.S. Constitution, it was a monarchial system similar to what we'd all escaped. And we're going to get into that really quick and how flawed the Hawaii Supreme Court was here, but how it demonstrates one side, the Leviathan side, the side that we need an all-powerful monarchy, an all-powerful centralized system where all the power goes there and they have to think exactly like you. And things like the First Amendment and Second Amendment are impediments to these philosophies. That's why you see such a big push for censorship by Silicon Valley. They call it something like fact check, which they've even admitted is just an opinion. And we know that all the fact checkers are paid by the people seeking the opinions that they want. So it's basically a sham. So these people are using the same techniques to try and fight against the Second Amendment, because that's very dangerous. Having an armed populace capable of resistance is extremely dangerous to a Leviathan type government. And this can be demonstrated with the ancient Hawaii Prince Kamehameha before he conquered the other rival warriors. And as you can see, there were rival princes after the main king. He was not able to take Kauai, though. So we'll talk about that later. But he was able to use cannons and superior weapons and Western technology and his friends in Europe to do that. So we have the kings allying themselves with the Europeans and taking on their technology and adopting their materialism, because materialism is really what this is about. It's not a race thing, and materialism is what really drives kings and pretty much anybody trying to make a living. You've got to have material things in order to survive, but some people become obsessed, and that's typically kings, because they've got idle time, they want to prove to the other kings they're better, whatever. The Hawaiian kings had great access to land. The royal family was able to subjugate the tribes, as you can see. The original King Kamehameha, he threw people off cliffs and stuff like that. He was not a good guy by any stretch of the imagination. So ultimately, Kamehameha was able to subdue Kauai and Niihau, but they were like the Scots. I can only compare them to how the Scots were with the English. They were holdouts. And look, when you go to Kauai today, the people in Kauai, they have a lot strong, different type of an aloha spirit. These people are very stubborn. They don't like outsiders, even worse than the other islands, right? They definitely don't like haoles there. So at least that's what they call us. I hope I don't get banned for saying that word, but that is a word used by people who look Asiatic, who live on the island, for people who look like they're white. But their real war and battle should be with the original kings and queens of Hawaii, which we're going to get into right now. So Kaimualu was forced to become a vassal of Kauai, of King Kamehameha, of the king of Hawaii, because of the threats of the European military firepower that they could have unleashed on Kauai. The other attempts to invade the Kauai in that island area there were thwarted by other things like diseases, and there was another one where there was like a storm, almost like the divine wind with the Japanese. They were saved by a storm, and it wiped out most of King Kamehameha's naval power that he had in the ocean coming across. Hawaiians are like the Scots, right? So, and they still act that way today. I just wanted to kind of point that out because there's a lot of similarities between English monarchies and Hawaiian monarchies, and people need to understand that it's about a battle not between our races and our skin colors, but a battle over the Leviathan or natural law. Where do our rights come from? A king, or do they come from an all-powerful creator, whoever that might be, or whatever that might be, that instilled with you certain unalienable rights? So that's where the battle is. So we can see that firepower was able to subjugate Kauai. Next. So we know that King Kamehameha used cannon to defeat the local warlords. A British subject named Young brought knowledge of naval and land battle strategies. So that's what gave him European technology, gave the king the power to subjugate his people. Very similar to how neighboring tribes of the Aztecs allied themselves with the Spanish to defeat the Aztecs. Everything they teach you in school is wrong about history. The Spanish, there weren't that many of them. They allied themselves with other Indian tribes to defeat. There was always battles between these tribes. So that's just normal. That's how it's always been. So anyone who argues that everyone's loyal to the king or anyone's loyal to one particular thing is wrong. Okay, so Young is the one who helped do that. So what ended up happening is Kamehameha II had, I think it was a brother who held joint power, and he was the caretaker of the god of war. So Kamehameha II kind of thought, okay, here's what I'm going to do. Because I don't want anybody interfering with my power. I'm going to abolish I think it's called the kapu system. And that abolished the traditional religions of the island. So he did that to try to hold on to power, really. And he was also, becoming westernized, because the more he accepted the European style systems and just the material systems from the big bankers and stuff like that, which usually is concentration of power into a few hands. What ended up happening is he sort of adopted that, and Hawaii became more Christianized. So there was an incredibly horrible war, a horrific war. And that resulted in Kamehameha III reversed those pro-Christian laws and revived the hula and other prohibited cultural practices. Now, many of the newly converted islanders were outraged. Stay tuned. Episode 2 is coming up. The newly converted islanders were outraged, but King Kamehameha III was no dummy. He goes ahead and promulgates a new law in 1833 outlawing weapons for use by common people. So this is what the Hawaii Supreme Court is harping on. They're saying, oh, weapons are outlawed, but by the king, and it's aloha, and that's great because the king said that weapons are bad. But remember why he did it. He did it because he wanted to kill everybody off and make sure that he could concentrate power in his hands. So that's why we have one of the reasons why we have a Second Amendment is to prevent exactly that. So you can see the Hawaii Supreme Court going along with the Leviathan, not the people. Okay, so what ended up happening is in 1848, King Mahele put through the Kaliana Act and stripped navies and stripped the natives of their land. So he passed the Kuleana Act in 1850, basically stripping the natives of their land, his subjects of their land, for cash. And the way he did that is because in aloha, in the true Hawaiian, not the people, the original Hawaiians who look like Samoans, their religion was, and their thought process was, there is no property. I just belong to my wife, whatever. They had polygamy. It was totally different. Like they didn't acknowledge, they didn't understand property rights the way the Europeans do. But the kings and queens adopted those European ideas in order to consolidate power. They even tried to do allodial title. They basically, the kings and queens of Hawaii basically took whatever was favorable to them from European ideas and basically took advantage of the fact that their subjects were not educated in that area of law or that system. So what they did is the Mahele allocated 1/3 of the land to the moat, the monarch, and another third to the ali'i and konohiki, the chiefs and the managers, kind of like his loyal subjects, not even a parliament. I mean, these are like his courtiers, right? Okay. So now the remaining 1/3 was given to the maka ai na'ana, the uneducated, mostly illiterate common people. If they filed within 2 years, they actually had to file within 2 years. These people don't even know how to speak English. They don't know anything about common law, American common law, allodial title, any kind of title. They don't know any of this stuff. And so that was the Kuleana Act of 1850 when all this happened. So the Kuleana Act, the king basically gives the local people 2 years to be able to buy their own land because the king wanted to convert over to a more of a European style property rights system. So he was already taking advantage of the good things about English common law, but he wasn't making it instituted with his own people. He was sort of, he was taking advantage of it for himself to be able to buy, trade, and sell himself. So now this land, since it wasn't filed in 2 years, what ended up happening is few Hawaiians made a claim, and most of their land was sold by the king's government to large corporations and people like that, out-of-towners. So the state ended up with about 32% of the land, and 4.8 of the land percent-wise went to the Hawaiian homelands. Natives had no concept of property rights. So I'm trying to get you through this quick. So on January 17th, 1893, the Hawaiian kingdom was overthrown by U.S. Marines because they were there under the guise of protecting American. So guys, I have Alan Beck here with me. Hi, Alan. How you doing, sir? You got comms? No comms. So we don't have any audio for Alan for whatever reason. Can't hear you, buddy. I have his sound on, so hopefully he's going to figure out what's going on with the sound. But that's kind of weird. He's probably got some issue with his sound. Maybe you want to log out and log back in, Alan. Not sure. I can just keep playing the video so people can learn the history of how it came to be that the Hawaiian Supreme Court argued. Can't hear you, buddy. No comms. Zero comms. No audio for you. You might want to do an audio check on your whatchamacallit. Nope, nothing. But guys, this is Alan Beck, and hopefully we'll get his sound issue squared away because he is, in my opinion, one of the preeminent Second Amendment rights lawyers in the country. And what I'm going to do is I'm going to keep playing this video for you until Alan is able to get his comm squared away. Interest after a coup was initiated against the Queen by a combination of locals and Westerners, people who had sort of taken up residence there. So she abdicated under duress to the United States, but the United States ended up annexing Hawaii in 1898. So that subjected it to the laws of any territory in the United States. All right, of their laws. But the Queen said something really interesting and telling about what the royals were really all about. She declared Hawaii to be her property in this handwritten letter, which I've included here. I wish I could make it bigger. What about now, Alan? But she did this handwritten letter where she said, "Talk to me, no sound. Taking a property without due process of law and without just or other compensation." So you can see. So guys, bear with me. I know it's not on my end. I've got all the audio squared away here. So there's got to be something going on with the interface. I'm looking at all my settings right now. Audio's good to go. Good to go. Just a weird thing. So he's going to try to square it away. But Alan, I'm going to keep playing the video so the audience can learn a little bit of the history of how it came to be that the Hawaiian Supreme Court argues that aloha spirit trumps the U.S. Constitution. And that's why they think it's okay to ban firearms. And basically, it's because King Kamehameha didn't want his subjects to be able to rebel against him, which is the exact opposite of why we have a Second Amendment, right? Let's keep listening. See that the king is relying on European-style laws, American common law laws, to get her property, which is Hawaii. It doesn't talk about her subjects, none of that stuff. She just wants her property back or wants to be compensated for it. That's really what this letter says if you read it through the eyes of someone who's not biased and brainwashed by a leviathanic educational system. Now, what ended up happening here is there's been this battle because of Hawaiians being a native people, at least the original Hawaiians. The people who are there now who say that they're natives were Filipinos and Japanese people that were there to do other work like cane fields and stuff like that. Now you're considered a haole and they're considered to be one of the original Hawaiians. And that's one of the problems with Hawaii is it has become really race oriented. And so the court has apparently ruled in this way. But what you'll see here, it really is more about the native traditions, and that's what I believe should be upheld. And so what it's saying here is that a reasonably exercised constitutionally protective Native Hawaiian right qualifies as a privilege when defending against criminal trespass charges. And that is a Native Hawaiian law training manual in 2022. So what the court is relying on is something a little bit different. The court is saying that, by the way, hunting in self-defense is a traditional right since 300 to 1400, before the royals took over and wanted to put down people from being able to fight against their unfair power. So that's what this is really about. So the Hawaiian norms and values from 300 to 1400 AD are in the Kanawai, and they enforce the social order. And you definitely had the right of self-defense. It was throughout their culture. Hawaiians were armed, they carried paddles with shark's teeth, whatever. All right, so here we go. But the Hawaiian Supreme Court argues that the law of the splintered paddle at 16 means that since it's a crime to attack women and children, like a real man wouldn't hit a woman or a child, what that really means is since a paddle was used, that paddles are illegal. That's basically their argument.
Now, Alan?
It's one of the most poorly reasoned and historically inaccurate pieces of literature I've
right.
So what I'm going to do, guys, I got Alan Beck. Everybody give me a bunch of ones for Alan. Thanks, Alan, for joining me today. Alan helps me in the San Diego area with catastrophic injury cases, and he also happens to be one of the preeminent Second Amendment rights lawyers in the nation. And I was just kind of going over the Wilson case, Alan, which is an older case. I believe you were involved in that case, weren't you?
I wasn't. That's a criminal case that went through the Hawaii state courts. I practice my Second Amendment cases are mostly in the federal courts.
Copy that. But I was giving them the background on how the Hawaiian Supreme Court and the government of Hawaii is relying on this ancient law where King Kamehameha basically is being used as a justification for banning firearms in Hawaii based on Hawaii's traditions that he made that were actually after their ancient law that went right, because the law of the splintered paddle made it to where the only people could have a weapon is the government, and how that's exactly when the king tried to seize our powder houses, that sparked off our Revolutionary War. And so how the court's trying to justify banning firearms based upon basically the law of the splintered paddle and edicts passed by King Kamehameha to sort of segue into our show today.
Yeah, it's so the Wilson case actually is not that old. I mean, it's I got denied by the Supreme Court less than a year ago. My apologies. I had some sort of technical issue with my laptop, so I had to switch to my phone. But the Wilson case got denied cert, I believe last year. It was either early this year or late last year. So the decision from the Hawaii Supreme Court is from last year. So I mean, we're not looking at something that's some 20-year-old jurisprudence. I mean, this is what the current Hawaii Supreme Court believes, is that the laws of the Kingdom of Hawaii trump the laws of the United States. And I mean, that's there's some issues for a lot of reasons. I mean, as you alluded to, Hawaii was being governed by a king at the time. So, it's really hard to see how the laws of any kingdom, the Kingdom of England or the Kingdom of Hawaii, have a application to our republican democracy. It's Beyond that, again, as you mentioned, I mean, that was a time where people effectively had no rights. So, and the laws of these laws were kept so that the people could not rebel against the monarchy. So it's there's a big reason I don't file cases in state court, and that's because in all likelihood the court of last resort, if you're filing in state court, is the Hawaii Supreme Court, and the Hawaii Supreme Court is not pro Second Amendment, to say the least. I mean, and because the reality is the Supreme Court doesn't take a lot of cases, and it's discretionary when you review with the the federal Supreme Court in D.C. So it's so I mean, typically I file my cases in the United States District Court of Hawaii, and I for the most part they try and at least not cite the laws of the Kingdom of Hawaii, at least when they're um, deciding my cases. And so Mike, did you want to discuss the Wolford case, or
Yes. I just wanted to sort of give them a background, and if possible, if you can sort of get your camera tilted a little so we can see you. There you go, looking squared away. So, Alan, just really quickly, can you just, in your own words, like just for a couple minutes, tell us a little bit about your background and how many cases you've argued before the Ninth Circuit having to do with the Second Amendment?
let's see, I've been an attorney since 2009. I began my practice in Hawaii. I since about 2011, I've spent a good deal of my practice in federal court. I've litigated, somewhere in the ballpark of I've I've done 17 federal appeals. I can't remember how many of those were Second Amendment cases in front of the Ninth Circuit, but but definitely the majority of them. Right. I've also practiced in the Second Circuit, the Third Circuit, the Fifth Circuit, D.C. Circuit, and the U.S. Supreme Court, and a couple other places. But so yeah, and I've argued quite a few appeals in front of the Ninth Circuit. Both in front of panels, and 2 times from the in-bank court, which is the 11 judges.
So, can you tell the audience a little bit about the difference between en banc and a regular panel?
Yeah. Typically, cases by a federal appeals court is decided by 3 judges, and you argue your case, the other side argues theirs, and you go. They issue an opinion. Occasionally, and this happens fairly frequently in Second Amendment cases, when the Ninth Circuit thinks that a case is very important, and they disagree. Well, and typically because they disagree with the panel opinion, the whole court, which is 29 judges, including the chief judge, will decide whether they will rehear the case. And if the majority of those 29 judges on the Ninth Circuit vote, it's a majority of the active judges. Currently, there's 29. If a few of them retire, for example, just be the remainder. But a majority of the active judges on the Ninth Circuit vote, and then 11 judges are randomly picked from the active judges and any senior judges that were on the panel that decided the original panel opinion. And they select 11 judges to represent the overall Ninth Circuit. And, I've had quite a few of those petitions in one form or another. And I've actually argued twice in front of the in-bank court, which is more than most attorneys, because, I think it's something like 0.4% of cases that are heard in bank. So it's very rare.
Okay, so that's one of the bragging rights that I have, is that I get to say that Alan's my buddy, because being a lawyer and somebody who's done quite a bit of appellate law when I got my start, primarily in habeas and in mandates and prohibitions, meeting a guy like Alan, who's far more experienced than me, and even having been licensed less time than me, is, well, not licensed, but a member of the bar, is very, very impressive to me. So it's always an honor to have you on my show, Alan. I really, really appreciate it. And everybody, give me a bunch of ones for Alan. He just recently got his black belt in Brazilian Jiu-Jitsu as well. So I think that's pretty impressive. So Alan, let's get into talking a little bit about what the Wolford case is about and how it came to be that Pam Bondi's Department of Justice with the Trump administration joined you in a basically saying, hey, we agree with you. I mean, isn't that a pretty rare thing? After you tell us about how this all came to be, and after you tell us about the Wolford case, walk us through the history and how this ended up happening.
I'd be happy to. So after, I litigated a case for about 10 years called Young v. Hawaii. And, that was part of a number of cases around the country that were challenging concealed carry laws. And the one of those cases, the Bruen case, went up to the U.S. Supreme Court, and the U.S. Supreme Court said that the good cause requirements that were available in in California, in 7 states total, New York, New Jersey, Hawaii, a couple other places, were unconstitutional. And good cause requirements were where they the government got to decide whether you had a good enough cause to carry a firearm. And that was normally, did you have carry a lot of money on you? Do you have a stalker, something like that? In general, self-defense was considered insufficient to get a permit to carry a gun. I had a case, like I said, the Young case, actually was heard by the Supreme Court just a couple months after the Bruen decision. And based upon the Bruen opinion, the Young case also won. And we received something called a GBR, which is a short summary disposition.
So Ellen, I don't want to cut you off, but most of the people in my sidebar probably have no idea what the Bruen opinion is. Could you just summarize it for us quickly so it makes sense to them?
Bruen was a challenge to New York's good cause requirement in order to get a concealed carry permit. The U.S. Supreme Court found that the good cause requirement in New York was unconstitutional and violated the Second Amendment.
All right, go for it and continue on. I hope I didn't mess it up for you.
Oh no, that's fine. After the Bruen opinion came out, the Hawaii, along with a number of other states, had to begin issuing concealed carry permits in a way they'd never had before. And as a response to the in response to the Hawaii legislature passed a law called Act 52. And what Act 52 did was do a big overhaul of Hawaii gun law, and for the most part, not in a good way. So what Act 52 did, as relevant to the Wolford litigation, was make it so that we acknowledge we have to issue concealed carry permits now. So we're going to make it so they're not good any place. And what they did was they made it so effectively, this is something we determined in litigation, 96.4% of the county of Maui, as a result of Act 52, is a no carry area. So it's, the only place where you can legally carry is a street and a sidewalk, along with private property. And well, I'll go into the nuances of this, but that's the only public property that you get.
Well, doesn't that effectively make it impossible for you to really carry, because you've got to always run back to your car, put your weapon in a locked container, run back to your house, put it back in your house if you want to go anywhere of substance?
That's correct. That's the whole point. Was they wanted to make concealed carry permits not effective anymore.
So what ended up happening? How did you get involved in this?
Well, yeah, I litigated the Young case, and I was pretty happy that the state finally issued issued permits after we'd received our decision, and the case was ultimately resolved in the trial court. Just then I found out not very long later they were going to make these permits, completely invalid, effectively, because they were, you wouldn't be able to use them anywhere. So a lot of people asked me. So I decided, what the heck, I'll take a shot at this. A few people that had reached out to me on Maui came and I represented them, and I just 8 days before the law was going to go into effect, I filed a temporary restraining order against the state of Hawaii, which to enjoin Hawaiian law. And well, I mean, I didn't get the injunction 8 days, but eventually the court did rule on it a couple weeks later, and the first court found that Act 52, at least parts I challenged in the lawsuit, was unconstitutional. And so people were able to start carrying again. Unfortunately, though, the state appealed the decision up to the Ninth Circuit. And the Ninth Circuit, there's a lot of stuff that happened, but I don't think your viewers really care about procedural stuff. They went and the Ninth Circuit upheld most of Act 52. And maybe the most important part of that opinion is they upheld a requirement that any private business put up a sign in their establishment saying that guns allowed if they want people to be able to carry. As a practical matter, no one will put up that sign because it hurts business to put up a guns allowed sign, and people typically will not do something affirmatively put up signs like that. And we have declarations of dozens of businesses that say we would be very happy with people submitting, which well done, carrying in our establishment legally, but we're not willing to take the hit on business by putting up one of those signs, because Hawaii is driven by tourism. You don't want people from places that don't have firearms get nervous when they see that sign and not frequent your establishment. So the Ninth Circuit upheld that. And that's why we're petitioning up to the U.S. Supreme Court. What's important is the court in New York, that's the Second Circuit Court of Appeals, has already struck down a similar sign law as unconstitutional. So something happened called a circuit split with the Ninth Circuit's order. And that's why we're very hopeful that the U.S. Supreme Court will review this case, is because the law simply is different in two parts of the country. I mean, if two courts of appeals rule differently, that means the law is different in two parts of the country. That's number one reason the U.S. Supreme Court will take a case.
So, Alan, really quickly, I just wanted to let you know that Wolf's Watch just joined us, and he donated $20 to the cause. And really quickly, to tell my audience what Alan is talking about, it's called a jurisdictional split. And this is one of the issues I was discussing with one of our other members, What's the Matter You, Alan, about when there's a jurisdictional split, that's when the referee comes in to decide the difference. Is that sort of a fair statement?
Yeah, and if anyone's interested in reading about this, they can simply Google Rule 10 of the United States Supreme Court's rules. And Rule 10 gives the criteria for when the U.S. Supreme Court will get involved. And circuit split is one of those.
Got it. Got it. And again, I wanted to thank Wolf's Watch. He said that he didn't see, he never got a YouTube notification. That's another issue, Alan, is YouTube doesn't like to notify my members. So I'm sure we'd get a lot more people in here if they would. But thank you, Wolf's Watch, for letting me know. Alan, are you still there?
I am, yes.
Okay, go ahead and continue, man. I don't mean to cut you off. I just want to be interactive with the
Oh,
audience.
no problem, no problem.
Okay.
Just stuff on my phone, I'm getting all sorts of notifications. I think that blanked me out for a second.
Got it.
So yeah, I mean, we did file for something called a stay of the mandate of the Ninth Circuit, and which was granted. So people can actually carry right now. The injunction we got from the trial court is in place while we pursue this matter with the U.S. Supreme Court. So I filed a petition for a writ of certiorari, which is a petition with the Supreme Court, giving out my reasons for why this court should grant it. Yeah, we were had a number of amicus curiae briefs filed. And one of those was by the Solicitor General's office, or by the United States. The Solicitor General's office filed on behalf of the United States. And, the Solicitor General's office acknowledges there's a circuit split, and they believe strongly that we're right and the Ninth Circuit was wrong.
And so, Alan, who is the Solicitor General?
The Solicitor General is that's the person that defends federal law from the United States on behalf of the president or the federal government in front of the U.S. Supreme Court and sometimes federal appeals courts.
Got it.
So
And in this case, is that Pam Bondi? I'm just trying to help people understand how Pam Bondi got involved in this.
Well, no, Pam Bondi is the Attorney General.
Okay. So you guys understanding how this works? The president or the federal government has their own Solicitor General, and they're defending, probably for one of the first times in recent history, the Second Amendment, right, Alan?
Yeah, so you can think about it like this. Pam Bondi is the Attorney General. She's sort of like the general. And the Solicitor General is the top special forces soldier. And he actually goes into the field and, does his thing.
Well, hold on a minute. You mean Force Reconnaissance Marine, right?
Sure, of course.
Right.
But you have a... the Solicitor General's office occasionally, though, takes positions for the federal government in cases where the federal government has a vested interest. And here, the Trump administration has made it very clear they care about the Second Amendment, and and since this case is the U.S. Supreme Court, they sent the Solicitor General to take the federal government's position, which is Hawaii law, along with all these similar sign requirement laws, is unconstitutional.
So, Alan, I don't know if you see this comment I have up on the screen from Benjai. Do you have a response to that?
I'm not sure what he means. I mean, isn't
it the court's job to throw out the case, not the government, not the feds?
Yeah, I mean, I think this is a Hawaii law, and the federal government can't really argue against. I mean, they did argue against in the brief. I mean, they did argue the law is unconstitutional.
Right, but since it's a Hawaiian law case, it's brought by the state of Hawaii, and they have got the 10th Amendment, right, on their side.
Yeah.
Right? Okay. Go
Yeah, I
ahead,
mean,
Alan.
the state of Hawaii has a right to, it's a sovereign state, it has a right to make its own laws, like any state. So, unless those are in compliance with the U.S. Constitution. But so, yeah, and basically, the Solicitor General's office, their brief says that we should go to the U.S. Supreme Court because Hawaii law is blatantly unconstitutional, as well as the laws of New York, which was correctly struck down by the Second Circuit. And there's very similar cases being litigated in Maryland and New Jersey as well on identical laws. And the U.S. Supreme Court should rule in my favor and then clarify that the laws in New Jersey and Maryland are also unconstitutional since those are identical laws.
That makes sense. And so basically, tell us about how the amicus came to be. Isn't that pretty rare for the government, the feds, to agree with a plaintiff's attorney or somebody who's fighting against an
It's rare. It's rare this happens. I mean, it's the I mean, we know that the Trump administration has taken a very strong pro Second Amendment stance, and I think part of that is they're filing briefs in court in support of the Second Amendment.
Yeah, I was pretty blown away. It seems like a sea change from what was going on with Sleepy Joe compared to what's going on now. So what's going to happen next? What's the next step in the litigation?
Well, in addition, by the way, we also had a brief by 26 U.S. states in support of us. So not only do we have the federal government, we have the majority of the country that so it's 26 states and the federal government thinks the state of Hawaii that we should be granted cert because the state of Hawaii's law is unconstitutional. So that's a lot of that's the majority of America, right? The federal government, 26 states, and a number of nonprofits also filed briefs. So I mean, what's going to happen is the U.S. Supreme Court is going to review my petition for certiorari along with all these amicus and the state of Hawaii's brief on September 29th of this year. And they need to make a decision, probably not on the 29th, but within a few weeks afterwards, right? On whether to take the case. And, I'm really crossing my fingers here that we'll be going up to the U.S. Supreme Court.
So, Alan, can you tell us what would be a reason why they wouldn't? I mean, you've got a jurisdictional split. The government of Hawaii has already admitted that there's no other factual or legal issues that need to be addressed with the original judge, correct? So
that's correct.
What would be stopping it?
Well, I mean, I don't know, but just remember that the U.S. Supreme Court only takes 50 to 60 cases a year, right? So you never can tell why they don't accept a case. I mean, I think we have very strong reasons, and I mean, I think that there's we've laid out exactly why, along with most of the country, on why the Supreme Court should take it. But let's just say that there's some major issues of federal law that are enjoined in the next month or two. Maybe the Supreme Court just gets too busy, and it says, "Well, we'll have to deal with this later."
Does that mean that there's still a chance if they don't hear it in September, it still could be heard at a later date?
In my case, yes. And the reason is that the U.S. Supreme Court is reviewing a preliminary injunction order. And what that means is that even if they deny review, the case would go back to the trial court. We would just keep litigating the case until we got a final judgment and then go back up to the U.S. Supreme Court at a later date.
Right. And that they could argue then possibly that since it hasn't been decided completely on its merits, that they'll wait until there's a final decision. Is that a fair statement?
That's a possibility, yes.
Okay. Now, but if they don't make the decision, these restrictions, would they stay in place, or how would that work?
Yes, the restrictions would go back into place. Act 52 would be allowed to go into effect.
Wow. So it would be, so if we were to compare this to marriage laws, let's say the government of California says you can't marry someone of the opposite race, but Hawaii says that you can. Does that mean if somebody from California moved to Hawaii, their marriage would no longer be valid? Is that a fair statement?
Yes.
Gosh, that's terrible.
So yeah, I mean, there would be a couple year period where Hawaii would be the only place in the country with this law in place, and I mean, I think that would be a very unfortunate result. I mean, we'd essentially be leaving the state of Hawaii out to um, you know out on its own, you right, as sort of a constitutional orphan.
Wow, that's not good. So, hey, Alan, is there a way you could pull the camera down just a little bit just to get your whole face in there? There you go. Thanks, buddy. It's just that you're cut off. All we see is the top of your head. There you go. Outstanding. So Alan, how do you feel so far about this? Do you have your fingers crossed? Do you feel 50-50? I mean, you've got so many states who have joined you as well as the federal government. I mean, do you feel pretty strong about this case moving forward to the Supremes?
I think this is as strong of a cert petition as any. That but outside of a federal law being joined and the federal government requesting cert, or say two states having a dispute, there's always a cert grant is always, it's nothing you could ever rely upon.
Got it.
So this is a very strong petition. We have a very good chance, but it's nothing that we can say for sure is going to happen. That's certainly for sure.
Is it fair to say that if it goes back down to the Hawaiian state court judge, that there's a low likelihood that you'll win just because it's a leftist court? Is that a fair statement?
I think that we'd be going back to a federal judge, not a state judge, and two, remember the Hawaii judge ruled our favor in the trial court. It was the Ninth Circuit that actually ruled against us.
Copy that. Okay.
Yeah.
So I'm just getting some clarification. So it's a Hawaiian federal judge, ninth district, right? Wait, hold on.
United States District Court for the District of Hawaii.
Copy that. Okay. And then the Ninth Circuit would be the appellate court, the Court of Appeals.
That's correct.
So it'll go back to this federal district court judge, and then the federal district court judge who's already ruled in your favor. So typically the
issue is that, I mean, a preliminary injunction is always preliminary. So she wouldn't be bound by the decision of the Ninth Circuit. However, it's at the bare minimum extremely persuasive for her. And for your viewers that don't know what I'm talking about, a trial judge is the first level. The appellate courts decide precedent, which the trial courts are required to follow. And in this case, the Ninth Circuit governs what Hawaii law is at the federal level. So the Ninth Circuit has already ruled in a preliminary basis in the Wolford case on the constitutionality of these laws. And by the way, I did win on two of the laws. There was a law on parking lots and a law on banks, which the Ninth Circuit found was unconstitutional. But
So Alan, just really quickly. So originally, just so the audience understands, the law restricted your ability to even have a firearm concealed carry in a parking lot?
In some parking lots, yes.
In some parking lots, okay. And so that was overruled. And what was the other one?
Banks.
Banks. So you could still conceal carry in a bank now.
That law has been struck down. The law that completely banned the concealed carry of firearms in banks has been struck down by the Ninth Circuit. The Ninth Circuit said there's no historical basis to justify a ban on banks by the government. However, the bank itself can ban firearms if they want.
Sure, and that's if they put up a sign saying no firearms allowed in our bank, right?
Yeah.
But what Hawaii was trying to do is say, unless there's a sign up that says you're allowed to, it's automatically banned, right?
That's correct. It wants to strip the rights of property owners away and make them the bank. There was no way for them to allow someone to carry a firearm in a bank, even if they put up a sign. So in banks and restaurants that serve alcohol, along with a number of other places we didn't challenge, even if they put up a sign, it was still illegal.
That's crazy. So, Alan, really quickly, Wolf's Watch, he just sent us another $10 donation. He's asking if he's saying only 3 or 4 have been approved in the last 5 years. Is that true?
That's not correct. He's thinking of before Bruen, 4 had been issued in the past 20 years. So before
Wow.
2022, four concealed carry permits have been issued in 20 years. 22 years since 2000. But since the Bruen opinion came out, and after we received a settlement in the Young case, several thousand permits have been issued.
So, in effect, I mean, if only a few have been issued, I can only venture to guess that it was probably issued to friends of law enforcement or friends or politicians. Is that a fair statement? That the ones that were issued to people who were politically connected?
Yeah, I mean, I think I know one of them was issued to the armor from the Hollywood Police Department, for example.
Okay, because isn't that kind of how it was in California as well?
Yeah, but
Yeah.
now anyone can get one. We're still litigating on in a lot of other cases over certain aspects of those licensing regimes, but they've issued a couple thousand, maybe between 2,000 and 3,000 in the past 2.5 years.
And isn't it sort of like de facto? It's really still kind of a ban because you're sort of like, I don't know. It's like, where can you really carry it? I mean,
Well, right now we have an injunction in place, so you can carry in most places. But if we lose this petition to the Supreme Court, then the injunction will go away, and then you're correct. You basically won't be able to carry any place.
gosh, it sounds like California with the magazine bans, where standard capacity magazines are legal 1 month, then they're illegal the next. It kind of makes you want to leave the state, you know?
Yeah, I hear you.
Well, so do you have anything else that you want to add? I'm going to look for questions from the audience while you're talking.
Well, I've worked very hard on this case. We've, I'm not being paid for this case. I'm doing this because it's something I'm very passionate about. We have raised some money for costs, and if I win the case, I'll try and get my money from the state of Hawaii, right? But it's so I certainly wouldn't be doing this if I didn't believe in it. There's a lot of easier ways to try and get the government to pay you money. That's for sure. So
Yeah.
it's but the reality is, I mean, I'm the only Second Amendment attorney in the state of Hawaii, and I did not. You have to keep the government accountable, and thankfully we've at least had our costs um, paid for. So I'm glad the Hawaiian gun owners have been able to put up some money so that I didn't have to pay for this out of my pocket.
Wow. That's
Yeah.
impressive. Do you have a GoFundMe link or any way that people can donate
We
directly?
have one, but I mean, I don't have a I don't have it in front of me. I can grab it but I think that'll make me go dark for a minute.
Well, what I'll do, Alan, is if you can shoot it over to me later, I'll drop it in the description so people can make donations directly to your cause. And I also want to thank Kinetic Customs and Racing. He just donated $2. He's talking about Wyoming having a proposed bill to make gun-free zones illegal. Are you aware of that?
I've heard of it.
Okay. You're not licensed to practice law in Wyoming, correct?
I am not. I'm only licensed in California and Hawaii, along with a number of federal courts.
Right. So you could always be invited pro hoc vice in order to get involved in a case like that.
Sure. In theory, if I could work in Wyoming pro hoc vice.
Now, Kinetic Customs just donated another $2, and he asked, Chevron deference overturned, hasn't done shit. I don't know if that's a statement or a question, but how do you feel about that comment?
That has absolutely no application to constitutional law.
Okay, fair enough.
Yeah, it's that's a completely different body of law.
Okay. All right, I'm just looking for other questions. So, Alan, I know that you didn't have a lot of time. I know that you're a busy jiu-jitsu practitioner and you've got a full caseload. So it means a lot that you were able to join me today. So when you get an opportunity, because I know you're busy, shoot me over that link and I'll drop it in the description for people to be able to help donate to your cause of standing tall for the Second Amendment. And with that being said, do you have anything else you want to add before we wrap up your appearance today?
No, thank you for having me on, Michael. This has been a great live stream.
Thanks, Alan. What I'm going to do then is I'm going to go ahead and disinvite you from the chat, and I'm just going to continue talking to the audience. Thank you, Alan, for joining me today. I really appreciate it, sir. And I'm hoping that we can go live more and talk about updates in the case, as well as other Second Amendment rights issues in the future. How do you feel about that?
That would be great, Mike. Love to be on again. All right, Semper Fi, Mike.
Semper Fi, brother. Take care, man. So, guys, that was my friend Alan. And as you probably already figured out, he's also an inactive United States Marine, and he's also into martial arts and Second Amendment stuff. That's another thing I love about my Marines is we all seem to have those similar likes and interests. And so it's just always a real blessing and a privilege to have somebody like him on my show, and I'm just super grateful. Let me see if I can I'm trying to figure out a way to screen share with you guys again. Let me do a stop and then let me do a start. Because if you guys want to stick around, I can continue on with the history of what happened here with the history of the Hawaiian law and what Hawaii is trying to argue, which is basically that King Kamehameha, who butchered his people, somehow he's revered by a lot of Hawaiians, outlawed their ability to defend themselves after thousands of years, at least, I believe, of Hawaiian history, where it was considered to be normal to have a weapon so you could defend your life and your family and hunt and things like that, defend yourself from foreign invaders, much like our Second Amendment. So if you guys want to stick around, I'll go through this really quickly and sort of let you learn a little bit more about the law of the splintered paddle, and how this evolved and how these Hawaiian lefty judges are arguing this crazy law to try to prevent you from exercising your Second Amendment rights in Hawaii. So here we go. Ever seen a fiction that I've ever seen in my life. So now it used to be, so after this, after the king passed these laws that basically tried to make it hard for people to rebel against him, a law was passed that people could carry a gun for good cause. So that's 1896. That was sort of ignored by the courts. And they're basically saying, well, it would require a permit first. But when you look at the history behind the permitting process, it was really just that it was a way to generate fees. There was no test. It was a shell issue. You pay the money, you're going to get to be able to carry your gun concealed. That's all that was about. That was 1896. So you could carry a pistol or a firearm. So there is a history under the Bruen case to establish this. Now, and that's called Republic of Hawaii versus Clark. It's an 1897 Hawaiian Supreme Court case showing that if good cause could be shown and good cause could be self-defense. So that's the point I'm trying to make. It's very, very terrible what's happening to Wilson here. So now, ultimately, Hawaii is bound by the Bruen case, even though they want to argue this hodgepodge of a strange historical interpretation. But just remember, folks, their historical interpretation is based upon a powerful monarch issuing an edict to quell the ability of his people to fight back against his unfairness. So that is something you really need to think about. You have to understand that the Leviathan does not want you to have the means to resist. And so it appears as though Hawaii is trying to rule by Leviathan. Bruen set a new standard for interpreting gun laws that the courts now had to do what they always used to do, which is look at the history behind gun laws coming all the way back from ancient England. And clearly, in this country, we've always had a tradition of being able to be armed in public or private, as long as it doesn't present a dangerous or unusual scenario. Now, dangerous and unusual would mean like going through a shopping mall on a horse with towing a cannon. That would be dangerous and unusual under the original common law understanding of what those terms meant, not what some modern court wants to create a new definition of something that never existed to then try and say it means something. And that's what these courts are doing, by the way. You have legislature giving definitions to the word for a centerfire rifle, calling it an assault rifle because it looks like one that's used in the military. So you have that. And what Bruen is saying is no, they have to be consistent with the nation's histories and traditions. Stay tuned. So you guys kind of got it. Now I've got another video. I'm gonna drop the link for you. The third video. Just give me 1 second, guys. I've got to open up a different window to share that with you, because if I try to share it with you on this particular sharing program, you won't be able to click on the link. So here it comes. Hopefully you guys can see that. Now, guys, look, I really appreciate the donations, and I'm going to get you there's the link for you. I'm going to get you a link so you can stand by. I'm going to get you a link to Alan's, whatever the donations channel is that he has, so you can help support him in his battle against Hawaii in trying to get the Second Amendment reestablished for the people of the state of Hawaii, so they have the same Second Amendment rights that our founding fathers intended for all free men to have. And now, to support my channel, I think that the best way you can support my channel is to buy blocks of subscriptions, because my goal is when you buy a block of subscriptions, it goes out to other people that YouTube thinks might be interested in the channel. What I'm trying to do is develop parallel systems where we teach people how to homeschool. We teach people about homesteading. We teach people about their fundamental unalienable rights. And we form a parallel system similar to how Martin Luther King Jr. formed parallel systems when shopkeepers excluded him and the Black community from being able to shop and things like that. So what did he do? He just boycotted everyone. And so I invite you to do the same thing. Everybody on my channel who's a member or a moderator is somebody who I believe is a good person and somebody who could help us build a parallel system where we, like Adam Smith's Wealth of Nations, if you've ever read the book, laissez-faire capitalism. You can have everything in life that you want if you can help other people get what they want. We obviously don't want parents shopping at Target where they support this concept that boys can be girls and girls can be boys. Public schools brainwashing kids into thinking they were born in the wrong body. Men competing in women's sport. We don't support that. We know that is like dog turd. And so what my channel tries to do is bring people who are like-minded together where we can form parallel systems and do business amongst each other. Now, although I do personal injury law to support my family, you'll see that on my channel, I don't push car accidents and truck accidents and try to get cases. I'm not grifting to try and get business like that. What I'm trying to do is teach you critical thinking and to get you out of the public school system, out of the university system, out of all that political re-education brainwashing, and try to restructure our government by forming a coalition. And one of the things that I would invite you to do is to get active. Why don't you run for school board? Why don't you get that blue-haired freak off of the school board, kick out the rainbow flag BLM mafia from the public school system, if you still believe in the public education system, and reclaim it for your neighborhood and for your family. But beyond that, obviously, I'm a homeschooler and I homeschool my kids, and I'm very active in the life of my kids to make sure that they're not going to be raised by my enemy. Just like Malcolm X said, why would you ever let your enemy raise your children? It's ridiculous. So pull your kids out of the leftist, Marxist-run education system, or get involved and reclaim it for your families, or run for sheriff if you think that law enforcement is behaving improperly. Get active and start reclaiming your government, just like the lefties did, right? You can do the same thing. And so that's really what this channel is about, is to try to form a broad coalition is you'll see that most of the people, thank you, Gloria, by the way, give me a bunch of ones for Gloria for the super chat. And I appreciate the $2, Gloria. I'm not looking for $100, $200. That $2 can go into a Roth IRA to help my kids who help me edit the videos and help me run the channel, teaching them how to be entrepreneurs. Now, that segues me into one of my upcoming shows. On Wednesday, Gloria, I'm going to have Brett Pike and Max Bonilla on. Max Bonilla is this young activist. He's going to explain the big, beautiful bill and how, with his help and me and a lot of you guys pressuring your local congressmen and senators, we were able to strip out that 10-year no regulations on AI snooping on the American people. We got that out of the bill. Look, I know a lot of you guys completely hate the system and don't want to participate in it, but I still believe that we can retake this government from these lefties and reclaim it for America and return us to a constitutional law republic, one person at a time. So I haven't given up on that. So, hey, good seeing you, SW Observer. And yeah, I agree. I think that D.A. Smith, Bitcoin definitely is something that I'm into. Originally, a couple thousand Bitcoin would buy you a piece of pizza. And now one Bitcoin is worth 108,000 USD at the last check. So although it's volatile, it'll go up and down. Don't treat it like it's a stock. And I'm not giving you financial advice. I'm not giving you legal advice. Okay. But for me, I don't treat it like a stock. I look at it as a long-term investment. It's actually something of intrinsic value. I'm a big-time crypto, gold and silver guy. I stack silver and gold. And I also invest in silver, gold, and platinum royalties. I've almost all but gotten out of regular stocks unless it's like MSTY or MSTU or MSTR or some kind of an ETF that's based on crypto or gold or silver or platinum. Other than that, I think that's the way to go. Me personally, the dollar is weakening. The American people are wising up to our fiat currency system, and the foreign bankers that stole our economic system from under our feet by basically paying off traitorous politicians like Woodrow Wilson and the Jekyll Island debacle of 1913. And we're seeing slowly but surely the dollar is weakening, and we need to go back to a currency that's based on something of intrinsic value, not smoke and mirrors of lying politicians. And so I'm looking forward to that day. And I would, if you guys are interested, I would be more than happy to bring on financial experts and advisors to talk about crypto, gold, and silver who are more qualified than me to talk about it, if that's something you'd like to talk about. I've been talking more about how to protect it, not just with a cold wallet, but trying to keep the government from civilly seizing it through forfeiture laws and things like that. Because we know when these scumbags that are in our government start running out of your money to pay off their voters, they'll try to seize your assets. Show me the man and I'll show you the crime. And that's what they're doing. So that's just something that I want you guys to think about. And Lenny Malley says that gold and silver are the only thing payable in debt according to the United States Constitution. Hey, no argument from me, brother. No argument at all. So let's go ahead and wrap it up. You guys have the link to my third video if you want to learn a little bit more about Hawaiian law, and how the lefties on the courts there are trying to use old law, basically arguing in favor of a powerful monarchy or restricting your rights and freedoms. That's the problem with the Marxists that have gotten onto the bench, really starting with Obama and then Biden as well, is that they always push for this centralized control over every aspect of your life. And if you disagree with them, they want to censor you, shut down your social media account. If you don't take the things they want you to put into your body, they'll say that you're a conspiracy theorist or an anti-you-know-whatter. Can't even mention it on YouTube. That's how much power these pharmaceutical companies have over these politicians. Billions of dollars in political donations, news media, advertisements. So, of course, the news is all going to say that you're a crazy person and a tinfoil hatter. And that's why I don't take sponsorships. I don't, unless it's like a homeschooler, like a Brett Pike, I would consider taking a sponsorship from him. But I am not going to sell out my belief system for anyone. And so I make my Federal Reserve notes and my fiat currency by working sometimes 10 to 12 hours a day and then bringing these shows to you on my own time, where I could be working on cases homeschooling my kids or taking my son to judo or, going to the gym, because I love my country. When I took my oath to uphold the Constitution as a young Marine, that oath has stayed with me forever. And so it's really important to me that we get the word out and we try to reclaim this country for we the people. Make sure that this country is for the American citizen, not illegals who snuck across our border to get free stuff, but for the American people and people who want to come here legally and conform to our culture and our way of life. And when in Rome, do as the Romans do, right? Would you let some weirdo into your house if you can't vet them and you don't know who they are? Of course not. Why would you let them into our country? So with that being said, guys, I'm really grateful that you showed up today. What's the matter, you, Lenny Malley? Well, aloha back to you, brother. And Kinetic Customs and Racing, my homie, and all my good friends, man. Gloria, you are so awesome. And I don't know if Jody Shiloh showed up today. And Wolf's Watch, man, I'm so glad that I got a new member. Guys, give me a bunch of ones for Wolf's Watch. Wolf's Watch, stick around a couple more shows and I'll make you a moderator as well. I just have to make sure that you fit in with the other guys on my channel because they all really earn their places as moderators. I mean, all my moderators are legit. Now, SWE Observer, let me just take a look really quick at your profile here because, man, you've been with me forever. And what we're going to do here is just take a look. Yeah, you're a moderator already. Okay, that's good. Guys, is there anybody else who's been on the show for a while that you think that I need to promote to moderator? Greg, you're already moderator. I see your wrench there. Yep, looking at all the wrenches. Looks like all the right people have them. Yeah, so Wolf's Watch, we'll get you up there with a wrench pretty soon. Now, Jeff, you've been around forever. So Jeff, you are now a moderator. So Jeff Rendell, if you're still here, with great power comes great responsibility. Don't abuse your privileges of being a moderator. It's really mainly meant to show the other moderators that you're a friend of Team MPE and a loyal subscriber, and not to time you out, right? Because I have moderators who are far left, moderators who are far right, moderators who are in the middle, but we all believe in the core value system that in natural law, that our rights come from our creator, not the state. And so that's what it's all about. I'm not looking for mind-numb robots. I'm not looking for Republicans or Democrats. I myself identify more as a libertarian, but I hate labels, but that's, if you were going to call me anything, call me a libertarian. I believe that less government means more freedom. And then Pro Se America, oh my gosh, well, yeah, bro, hold on one second. Pro Se America, you deserve it, dude. You've been here forever. Let me find you on the other. All right, same speech here. I got to find you. Hold on, man. I'm on the wrong freaking, got to find you over here. Sorry, guys. Again, I'm not the most savvy. Hold on. I'm not the most savvy guy when it comes to technology, guys. So just give me 1 second. All right, Pro Se America, you are now a standard moderator. Again, same thing, brother. With great power comes great responsibility. I'm not looking for you to just be timing people out or throwing your weight around. We know you're a good guy. We love you, man. And, shukran for joining me on the show and staying a loyal member of Team MPE. I know none of us agree on everything. And again, the main thing is that we agree on the important things. And so that's what I love about Team MPE and the organization that we're building, the network that we're building. Now, if Rami's still here, or maybe What's the Matter You or Kinetic Customs, a lot of people are telling me that I need to set up what's this? It's like a channel. Man, I forgot what it's called, but it's, a lot of people are telling me I need to do this. So we have like an online, aside from the channel network, the same thing that John Felix has. I just can't remember what it's called, but yeah, if any of you guys want to help me with that, setting that up. Hold on 1 second. Hold on 1 second, guys. Yeah, buddy, I'm still live. I'll call you right back. Okay, bye. Yeah, so sorry, that was my buddy Alan. Guys, give me a bunch of ones for Alan, by the way. I mean, I really love that guy. To me, he is probably the most humble lawyer I've ever met in my life. This guy has won multiple appellate court cases in favor of the Second Amendment in a very hostile, in my opinion, far left judiciary. I mean, you've got the Ninth Circuit. I mean, come on, guys. I mean, give me a bunch of ones. Ninth District Court of Appeal, forget about it. So super good guy. And give me a bunch of ones for Dick Heller for really starting all this into action. DC versus Heller, my friend Dick. What an amazing thing. I mean, I have the most amazing, blessed life to have friends who are part of living history of this country. And it just really makes me proud, man. Like, just to have people like this who have agreed to allow me into their life. And what's that thing called again? It's a website called Extron or oh gosh, it's just on the tip of my tongue. Somebody, well, anyways, you guys know what I'm talking about. I think it's not a Reddit page. No, it's another one where everybody's doing them. Discord. Yeah, Greg, Discord. Yeah. So Greg just said it. So if somebody's interested in me setting up a Discord channel, I've seen a lot of guys where they try to charge money and stuff. That's not my deal. I would like to create a Discord channel where people can present ideas to me for my show, because I want to give the people what they want, right? I mean, I'm not doing shows necessarily because I want to make myself look good. If that was the case, I'd be trying to do videos of car accidents and tell you to call me if you got in a car accident. So the other one, so Proton and Discord, Let's OTVO. And Let's OTVO, say hi to Brick for me, bro. I miss the guy. Super cool guy. I wish he'd stop by once in a while. I know I haven't really been visiting your guys' channels, and I apologize for that. I've been struggling pretty hard with sciatica and just trying to get back in shape. I've been doing the creatine, glucosamine, glutamine, going to the gym, methylene blue, DMSO, and MSM. And a lot of different stuff like that. Rami's really helped me a lot controlling my nerve pain because I was dragging my left leg everywhere. So doing these shows is really, really hard for me, but I really, really appreciate you guys joining me and sticking around. And Jody Shiloh, good seeing you, ma'am. So we are going to, we'll create a Discord then. I'll ask Rami to help me do that. Rami's a good buddy of mine, and he's more technical with those types of things. And I'll have him teach my kids because they're helping me with the channel a lot, you know. So with that being said, guys, I'm going to go ahead and call it a day. Have a terrific Sunday. God bless all you guys. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.